de la Asamblea de los Estados Partes del Estatuto de Roma de la Corte Penal Internacional. Es un privilegio y un honor para mí darles la bienvenida a todos en esta sesión, que estamos celebrando una vez más bajo las limitaciones relacionadas con COVID-19. Como a todos ustedes me entristece el deterioro de la situación y me frustra que esto nos haya obligado a restringir aún más la participación, tanto de los estados como de la sociedad civil, y que haya obligado a algunos a cancelar su asistencia a esta asamblea. Aún así confío en que aún podremos tener una sesión vibrante y productiva. Espero escucharlos a todos e interactuar personalmente con al menos algunos de ustedes durante esta semana. Agradezco al Estado anfitrión por su flexibilidad en permitir a la Asamblea que pueda implementar sus propias medidas en relación con la pandemia, lo que nos permite facilitar el acceso de representantes a esta Asamblea. Pueden estar seguros de que el Centro de Convenciones del World Forum ha implementado medidas para disminuir el riesgo de exposición al virus para los participantes y los insto a todos a respetar las medidas implementadas. Les agradezco a todos por su paciencia y comprensión. Como saben, nuestra agenda para este periodo de sesiones es ambiciosa. Discutiremos en particular los temas fundamentales de la cooperación y el proceso de revisión de la Corte y el sistema del Estatuto de Roma. Aprobaremos el presupuesto para el 2022 y elegiremos miembros de órganos importantes como la Junta Directiva del Fondo Fiduciario para las Víctimas y el Comité Asesor para las candidaturas de los magistrados. Por último, pero no menos importante, elegiremos 2 fiscales adjuntos. Antes de continuar, levantémonos y guardemos un minuto de silencio dedicado a la oración o la meditación, en particular por las víctimas. Muchas gracias. Sobre la base de un sorteo realizado en la mesa, la delegación de Australia se sentará en el primer escritorio a la derecha del presidente. Todos los demás estados siguen el orden alfabético en inglés. Como bien saben, con el fin de minimizar el riesgo para la salud y el bienestar de todos los participantes, la mesa ha decidido que el número de representantes de los estados partes en el Centro de Convenciones del World Forum en cualquier momento determinado se limitará a 2. Distinguidos delegados, de conformidad con el párrafo 1 del artículo 112 del Estatuto de Roma, los estados que no sean partes en el estatuto, pero que hayan firmado el estatuto o el acta final de la Conferencia de Roma, podrán participar como observadores en la Asamblea. Los estados observadores pueden participar en las deliberaciones de la Asamblea, pero no pueden participar en la toma de decisiones. Aquellos estados que no son partes del Estatuto de Roma y que no han firmado el acta final o el estatuto no tienen la condición de observador. El artículo 94 del reglamento establece que al comienzo de cada periodo de sesiones de la Asamblea, el presidente podrá invitar a esos estados a estar presentes durante el trabajo de la Asamblea, sujeto a la aprobación de la Asamblea. Propongo que la Asamblea invite a los siguientes estados que no tienen la condición de observador a estar presentes durante el trabajo de la Asamblea: Bután, República Popular Democrática de Corea, Guinea Ecuatorial, Eswatini, República Democrática Popular Lao, Líbano, Mauritania, Micronesia, Myanmar, Niue, Palau, Papúa Nueva Guinea, Ruanda, Somalia, Sudán del Sur, Tonga, Turkmenistán y Tuvalu. ¿Puedo considerar que la Asamblea desea invitar a estos estados a estar presentes durante su labor? No veo. México tiene la palabra.
Muchas gracias, señora presidenta. Felicitaciones por su conducción y los mayores éxitos durante esta conferencia. Solamente consultar, en la medida en que estas delegaciones son invitadas, ¿no tienen que presentar cartas credenciales o sí?
Muchas gracias por su pregunta.
Buenos días. En efecto, los estados observadores no presentan cartas credenciales, simplemente nos presentan una nota comunicando la composición de su delegación. Ni los observadores ni los estados invitados presentan las credenciales. Gracias.
Espero que esto haya respondido a su pregunta. ¿Puedo entonces considerar que la Asamblea desea invitar a estos estados a estar presentes durante su labor? No veo ninguna objeción, así queda decidido. Se han reservado asientos para los estados observadores y los estados invitados. Debido a las limitaciones causadas por la pandemia, se permite la entrada al Foro Mundial de un máximo de 2 representantes de esos estados en cualquier momento dado. Solo un representante puede sentarse en esta sala detrás de un micrófono, mientras que el segundo deberá sentarse en la parte trasera o en el balcón. Deseo dar una bienvenida particular a los representantes de los estados observadores, tanto aquellos que están presentes con nosotros en el centro de convenciones como los que nos siguen vía Internet. Como siempre, la Asamblea aprecia sobremanera su presencia y participación en nuestra sesión. Estamos conscientes de que muchos de ustedes deseaban y habían planificado viajar a La Haya, pero el deterioro de la situación epidemiológica ha impedido que puedan acompañarnos. También se han reservado asientos para las organizaciones no gubernamentales invitadas en virtud del artículo 93 del reglamento. Una vez más, las limitaciones sanitarias nos obligan a limitar a 16 el número de ONGs presentes en el centro de convenciones en cualquier momento dado. Realmente lamentamos mucho todas estas restricciones, pero les agradezco a todos por su comprensión. Ahora vamos a abordar la aprobación de la agenda. El programa provisional figura en el documento ICC ASP20/1 y un programa anotado en el documento ICC ASP20/1/Adendum 1. ¿Puedo considerar que la Asamblea desea aprobar el programa que figura en este documento ICC ASP20/1? No veo ninguna objeción. Se aprueba el orden del día que figura en el documento. Y ahora tengo martillo. Voy a continuar mi presentación en inglés. Report on the activities of the Bureau. Distinguished colleagues, in accordance with the agenda we have just adopted, we will hear a number of statements this morning. In order to minimize any health risks, I would ask all speakers already on the podium to please speak from their seat. I thank you for your understanding. As the President of the Assembly, I have the honor to report on the activities carried out by the Bureau of the Assembly of State Parties this year. The full oral report of the Bureau will be included in the official records of this session. In the interest of time, I will not read this in detail. However, I do wish to make a few remarks at this point. Indeed, I have the honor to report to the Assembly of State Parties on the activities carried out by this Bureau since 13 February 2021. In light of the circumstances caused by the COVID pandemic, the 9 meetings held by the Bureau this year have been held virtually. The working groups of the Bureau, facilitations and focal points, as well as the review mechanism, also met virtually. The Bureau assigned mandates to its working groups and appointed, on the basis of their recommendations, the facilitators and focal points for 2021. The Bureau deeply appreciates their work as they have successfully carried out the mandates of the Assembly. I also wish to express my sincere appreciation for the work carried out by the 2 Vice Presidents of the Assembly, Ambassador Bob Ray from Canada and Ambassador Katerina Sekwensova from the Czech Republic, in support of the work of the Bureau and as the coordinators of the New York Working Group and the Hague Working Group. In accordance with the mandate of the Assembly, the Independent Oversight Mechanism, IOM, submitted the annual report of the head of the Independent Oversight Mechanism to the Assembly and also provided invaluable assistance to the design and implementation of the due diligence process approved by the Bureau for the selection of candidates for the positions of 2 deputy prosecutors. I wish to express my appreciation to the head of the IOM, Mr. Saklen Hedarali, for the important work undertaken by him and his office. I also wish to express my gratitude to the Secretariat of this Assembly. Throughout the year, the Secretariat has continued to carry out its mandate in assisting the Assembly and its various groups, facilitations, and the review mechanism both in The Hague and New York. The virtual format of the meetings continued to pose additional challenges, including scheduling meetings across multiple time zones, additional testing of numerous platforms required prior to meetings, and finding solutions for the provision of interpretation where necessary. At its first meeting in February, the Bureau agreed to engage in a lessons learned exercise with respect to the last prosecutor election process. To this effect, the Bureau requested and received reports from the former presidency of the Assembly, the Committee on the Elections of the Prosecutor, and the panel of experts. On 2nd November, the Bureau adopted a proposal on the mandate, principles, products, and deadlines of the lessons learned process, as well as the appointment of 2 state representatives as the facilitators. They are now reviewing the background material and will start their preparations and consultations in the first trimester of 2022. I propose to invite them to report to the Bureau on their activities as soon as feasible in that first trimester. Also, during this year, the Bureau adopted a joint proposal with the prosecutor on a due diligence process to assess the high moral character of the candidates for the position of deputy prosecutors. This process was implemented as foreseen, and on 18 November, the IOM submitted to the Presidency a report concluding that there was no evidence of misconduct that warranted informing the Assembly as to the risk that any candidate may not be of high moral character as required by the statute. The Presidency accepted such conclusions and reported to the Bureau that therefore considered that no further action was required. On 24 November, the Bureau took note of this oral report. The Bureau will subsequently consider whether this experience could be applicable to other future elections. Regarding the election of deputy prosecutors, divergent views were expressed by Bureau members regarding the interpretation of Article 42(4) of the Rome Statute, in particular, whether the state should select the candidates from one list of 6 or 2 separate lists of 3 candidates. The Bureau agreed to recommend to the Assembly that A, the election of the 2 deputy prosecutors take place on the basis of List A and List B as submitted by the prosecutor to the Assembly. B, the election of the 2 deputy prosecutors be done successively so as to ensure equitable geographical representation of regions and legal systems. The order of the election between the 2 lists would be determined by drawing lots at the Assembly on the day of the election. The Bureau also agreed that its recommendation is understood to apply solely for the purpose of this election and should neither be considered as a precedent for future elections nor construed as acceptance by state parties of the interpretation of Article 42, paragraph 4 of the Rome Statute that resulted in the presentation of 2 distinct lists. The Bureau considers that this matter requires further consideration and discussions at the earliest opportunity in 2022. Distinguished representatives, since the start of my presidency in February this year, I have used every opportunity to highlight the importance of the court as a central piece of a global system of justice. I have stressed that for the court to discharge its crucial mandate in light of contemporary challenges, it is necessary to take actions in 3 areas, namely to review the entire Rome Statute system with a view to improving and strengthening its functioning, increase cooperation, and support and enhance universality of the Rome Statute system. To this effect, I have engaged with the diplomatic community in The Hague and New York, and have also actively reached out to civil society organizations. In September 2021, I visited New York, where I delivered remarks at the annual meeting of the Informal Ministerial Network for the International Criminal Court, and met with representatives of state parties, high officials of the United Nations, and civil society organizations to foster understanding and cooperation for the court's activities and seek to enhance universality and political support. I have also specifically discussed the importance of countering the instances of non-cooperation. In this regard, I have indicated in the context of discussions of the review mechanism that it would be important to address in 2022 the recommendations of the independent experts on external political measures against the court. During this year, I have engaged on several occasions with the Board of Directors of the Trust Fund for Victims, which I consider a crucial component of the Rome Statute system. I have emphasized on multiple occasions the importance of supporting the Trust Fund for Victims and wish to express my appreciation to states that provide financial contributions to their activities. In concluding, I take the opportunity to thank all my colleagues of the Bureau for their hard work and invaluable cooperation and support to me during these intensive 10 months. I thank you for your attention. May I take that is the wish of the Assembly to take note of the oral report of the Bureau? I see no objection. It is so decided. The Assembly has thus concluded its consideration of Agenda Item 9. Now we will turn to Item 6, Report on the Activities of the Court. This report is contained in document ICC ASP20/9. We are honored to have the President of the Court, the Prosecutor, and the Registrar present today. On behalf of the Assembly, it gives me great pleasure to extend to them a warm welcome and to assure them of the continuing support of the Assembly in the discharge of their respective responsibilities. The Assembly is aware of the enormous responsibilities inherent to your offices. I will invite the President of the Court and the Prosecutor to address this plenary today. The Registrar, Mr. Pistol Lewis, will deliver remarks to the Assembly when we take up Agenda Item 16 on considerations and adoption of the budget for the 20th financial year. I shall first give the floor to the President of the Court, Judge Piotr Hofmanski. Judge Hofmanski, you have the floor, please.
Madam President of the Assembly, Mr. Prosecutor, Mr. Registrar, Madam Chair of the Board of Directors, Excellencies, distinguished representatives of states and civil societies, ladies and gentlemen, it's a great pleasure for me to address the Assembly of State Parties for the first time in my capacity as President of the Court. I would like to begin my remarks by thanking all states, organizations, colleagues, and others who have given their support to me in my new roles and since I was elected President on the 11th of March this year. I really appreciate it. Madam President, if I had to summarize in one sentence what I want to say today, it would be this. The Court is on the good path. The Court is doing more than ever in those concrete delivery of justice through investigations, trials, and reparations. The Court and the Assembly are working closely together in the review process, which is already yielding positive results. And the Court has survived the most challenging period of institutional threats against it since its creation. None of this means that our daily work is simple or easy. Far from it, but it is reassuring to see the Court succeed in discharging its mandate, while it is also improving as an institution. I will not enter into the details of the Court's judicial work here, since the allocated time slot is far too short for that. Suffice is to say that the Court is very busy, working at full capacity and speed. In the past 12 months, a large number of significant decisions were issued, including 2 major appeals judgments, 1 trial verdict, 1 sentencing decision, 1 reparation order, 2 decisions on the confirmation of charges, 1 decision authorizing an investigation, and so on and so forth. And despite of the significant challenges posed by the global pandemic, the proceedings in our courtroom have non-stop at any point 2 trials have been occupying our courtrooms this year. 2 more will follow next year, and there could be a 5th one as well. We may well be handing to the court's busiest year ever in terms of trial proceedings. Meanwhile, the number of situations before the court has reached the record level of 16, more than double from 10 years ago. The workload of the Trust Fund for Victims has equally increased in a dramatic manner in recent years, as it plays a key role in delivering the reparative aspects of the ICC's justice system. All of this shows the ICC is doing the job it was created to do, and despite challenges. It shows that the court is relevant and legitimate. And it shows that the court enjoys broad support and cooperation, as without that, all this work could not be carried out. One more note. I would like to express the court's sincere gratitude to all those states, parties, other states, international and regional organizations and NGOs that have extended their support and assistance to us in the past year. Thank you. Madam President, apart from the unprecedented workload of the court, a theme that has strongly characterized the past year is the review of the court and the Rome Statute system. The review resonates strongly with my top priority as a president of the ICC, which is to enhance the court's delivery of justice in every way possible. Independent, impartial justice, fair to all parties and participants. Since day one of my presidency, the court has been working closely with the assembly of the review process. We must make it a shared success of the whole Rome Statute system. We have already seen the usefulness of the AIR report, as it has pushed us all forward to tackle many areas where improvements can be made. We may not agree with each and every recommendation, but that was never the point. The main thing is that the process as a whole creates positive change. It is not easy for judges to work on the complex IO recommendations on the top of the heavy judicial workload. But we are doing it, and we have made a lot of progress. Just 2 weeks ago, at the annual Judges Retreat, it's a tradition started by President Fernandez. The court's judges jointly decided on several important measures in response to the AIR report, which a view to enhancing the efficiency and consistency of proceedings before the court. These agreements, which concerns the pre-trial to trial transition, the conduct of trial proceedings and the approach for victims' applications, will be reflected in the Chamber's practice manual as well as proposed amendments to the regulations of the court. Discussion at the retreat will also address questions related to the collegiality and workplace culture. The latter issue is in particular is one of the highest priorities for the court's management. We must guarantee a safe and fulfilling working environment for everyone in the court. The court is doing a lot on this front. We have appointed a full-time focal point for gender equality, and she has already made a tangible impact. We are creating an ombudsman person next year if the Assembly approves the budget for it. We are right now conducting a staff engagement survey to get updated and more detailed perspectives on the staff members on their working condition. We are also far advanced in updating key administrative issuances aimed at addressing bullying, harassment, and related matters. And we are soon launching public consultation of the court's first comprehensive institution-wide strategy on the gender equality and workplace culture. On top of all this, I want to show example by digging deeper into this topic in my own immediately area of responsibility, the judiciary. To that end, I have requested the independent oversight mechanism to conduct an evaluation of the staff working condition, the presidency and chambers. I hope the SP will approve this as part of the IOM's work plan for the next year. I want to get an in-depth, independent evaluation of the state of affairs so that we have a precise picture of where problems lie. Madam President, at the beginning of my remarks, I referred to the deeply regrettable period of attacks and sanctions against the ICC, which is thankfully now behind us. The period taught us that the court, its mandate and its independent operation cannot be taken for granted. In that context, I urge the Assembly to give utmost attention and deep consideration to recommendation 169 of the independent expert report. It is essential that we are all better prepared for possible future threats against the ICC. If the court is allowed to do its work independently, which is the cornerstone of this very idea as a judicial institution, then we are bound on the end to end up on a collision course with powerful interests every now and then. The ICC community of states and stakeholders must make it abundantly clear to the world that the court and its independence will be safeguarded with utmost guidance. We cannot afford to compromise on the rule of law, and that is ultimately what the ICC represents. I am of course aware that the rule of law in the international arena is not exactly the same thing as it is in the domestic setting, but the two are very closely connected, and we must promote both. I believe this is also one of the questions that should form part of the discussion of the long-term strategic vision of the ICC provided in the recommendation 363 of the IO report. The court stands ready to work with the Assembly on this important matter. Madam President, thank you for this opportunity to address the community of states and other stakeholders gathered under the umbrella of the Rome Statute. As President of the ICC, I pledge my full commitment to leading the court forward as well as I possibly can in the next 2 years, and working closely with you and everyone else here for the cause of justice, as we have indeed done so far. Thank you very much for your attention.
I thank President Hofmansky for this very concise but still comprehensive statement on the impressive and intensive work at the court. I thank you very much, President Hofmansky, and I now invite the prosecutor of the court, Mr. Nkaringam, to address the Assembly.
Madam President of the Assembly, Silvia Fernandez de Gamendi, Mr. President Hofmansky, dear Mr. Registrar, I'm seeing the Chair of the Board of the Trust Fund for Victims, Excellencies, distinguished delegates, it's an immense privilege and honor to address you in this very important occasion, my first address as prosecutor of the court. Since I was appointed commenced my term on the 16th of June, there's been a great deal of activity for which I commend every member of the office for playing their part. I will also touch upon the wonderful support I've had for so many at the end, including the principals that I have the honor of sitting alongside at this table. Wonderful engagement with many of you, representatives of state parties, and also constructive engagement with non-state parties and civil society. We have started a process that has a way to go, but it is a start that will require the refocusing of the energy and skills of the office to help ensure that we make a greater impact. In this regard, I'm tremendously grateful for the work of the independent expert review. It put up a mirror to the court at a very important time. And many of those recommendations definitely deserve to be embraced. And I will do so in full conformity with my Article 42 responsibilities for the management and organization of the office. The simple truth, as the IAR report discloses, is that the time for change is ripe. It is now. As we approach the 20th year of the coming into force of the Rome Statute, we need to build upon what works, the achievements that undoubtedly have been made, but with a constructive but critical self-reflection and degree of introspection that we need to do better. Because all of us in this room, and those distinguished members watching online, civil society in the field, state parties or non-state parties, have to face an ugly reality that for far too many individuals, there is a lack of protection. They suffer. And there are these islands of impunity that cannot be tolerated in this 21st century. I will make every effort to bring about change. The staff that I have the honor of leading work tremendously hard. We deal with expectations that perhaps also need to be moderated based upon an understanding of what international criminal justice can do and what it cannot do, what the court has, what resources are given to me as prosecutor to do my job, and to focus what we have in an intelligent way so that we can make a difference. Before I was elected, and I stated it to the distinguished delegates and state parties in roundtables, I was convinced that this office should be the most exciting, the most vibrant, and the really most wonderful place in the world to work. Yet, as the IAR report discloses, it is not. And this is not apocryphal. As I walk the corridors of my office, as I have had my weekly open door policy with staff, I can see that for far too many of them, their enjoyment depends upon who they work for, which team they are in. There are changes that we have to bring about, and to this end, I'm very grateful for the advice that I was so generously given both by the registrar, by the head of the IOM, and I've had discussions with all of the principals, and I've appointed a workplace panel of experts outside of the line of reporting that staff can go to in safety. It's a safe space with full confidence, so that any issues of harassment or bullying or sexism or racism can be properly put forward. And so I am given some granularity further to the IAR report. One commitment I make without hesitation is that I will not speak the language of zero tolerance and fail to implement it. I think that is the very least that is required of me. On Friday of this week, we have a workplace panel side event chaired by Mr. Ibrahim Pam, in which all the panel members will be speaking, along with my newly appointed special advisor on workplace culture, Ms. Perna Sen. And I do hope that some of the distinguished members in this room and those online would have time to watch it, and if they are otherwise engaged, to watch the recording. I've also appointed special advisors on new areas, about 20 special advisors, but on new areas such as gender persecution, on slavery crimes, on Islamic law, on knowledge transfer, and this week I will announce the appointment of a new special advisor from Japan on mutual legal assistance. One other thing is clear, that gender parity, gender equality, and proper fair geographical distribution is not a tick box exercise. It is essentially linked, particularly in the work that we all do, to the delivery of the mandate of the court. It is important to understand the regions in which we operate, and hearing the perspectives from a variety of individuals is also critically important to understanding intersectionality when it comes to the crimes that are targeting civilians, and when we hear the stories of victims and survivors. Before I was elected, and in the first 6 months of this current mandate, I have repeatedly emphasized, and forgive me for underscoring it again, that complementarity is a key aspect, a key bedrock foundation of the Rome Statute system. And my own view, subject to witness security, logistics, finance, and of course the decisions of the independent judges of the court, The Hague should not only be, the ICC should not only be a court of last resort, but The Hague should be a city of last resort, and we should look at concrete ways in which we can build partnerships to bring the court closer to the affected communities. I think, indeed I'm convinced, that the impact would be greater if we do that. My missions to Colombia and Venezuela may provide an insight into new models that I believe are fully consistent with the Rome Statute and which are capable of bringing about real dividends. I recently went to Bogota in Colombia, and I announced the closing of a preliminary examination that had been open for 17 years. I did so because a proper assessment of what Colombia had put in place, the $120 million a year it was providing to the Special Jurisdiction for Peace and the Justice and Peace Tribunal, could not disclose a lack of genuineness. There was no evidence to find unwillingness and inability. And realizing the function of preliminary examinations as a filtering function, I was compelled to close. But with the wonderful support of the Colombian ambassador in this room, with the Colombian government, we started what I think is a new paradigm of engagement, constructive engagement outside of the preliminary examination, by way of an agreement that the President and myself signed when I was in Bogota. This is something that I would urge everybody to support. It would be a way of securing the independence of the Special Jurisdiction for Peace, to ensure that there is no political interference with it, and that it is properly funded, and it is a way to work closer with states instead of unnecessarily diluting our efforts in a way that would otherwise be quite possible. I was delighted to accept an invitation by the President to visit Colombia again next year, and I hope we will have ever closer relationships and supporting the Special Jurisdiction for Peace and the quest for Colombia is making to deal with impunity, to deal with the crimes and the suffering that have befallen them for far too long. And this is completely consistent with what I've said repeatedly. The forum is not important. What is important is there should be no deserts of impunity. We need to water the ground and create oases of accountability wherever possible. And I was also delighted to visit Venezuela, and I'm very grateful for the interaction with the ambassador of Venezuela here. I had very good meetings with the president also of Venezuela, with the senior members of the government, and in the presence of the president and senior members of the government, I also announced an opening of an investigation. I do think it's important to underline to everybody what I emphasized when I was in Caracas, that preliminary examinations are a filtering process. And when investigations are opened, there's no preordained targets. There cannot be. There's no preconceived outcome. The job of any independent prosecutor and the job of my office is to follow the evidence and see what actually is the reality. See if Rome Statute crimes are committed, and if they are committed, to see whether evidence discloses who is responsible. This office is not in the regime change business. It simply and must solely try to address impunity and investigate independently. But what was important in Venezuela, in a first, in fact, was that at the same moment I opened a preliminary an investigation, I signed with the president of the Bolivarian Republic of Venezuela an agreement which shows that together with investigations, in parallel with investigations, we can have cooperation based upon complementarity, and I look forward to constructive and sustained dialogue with Venezuela to address impunity in national proceedings. I look forward to going to Venezuela also next year and to further that interaction. As these two examples show, Venezuela and Colombia, it signifies a new approach perhaps to preliminary examinations. The comprehensive review that I have started, looking at preliminary examinations, looking at policies, investigations, will seek to use the finite resources of the office more effectively and to build cases that will survive challenge in the courtroom. I hope to announce certain decisions on preliminary examinations before the end of the year, and in relation to all outstanding matters, come to those determinations by the end of next year. Of course, new preliminary examinations will be opened, and new investigations indeed, whether by Security Council referrals, state referrals, or Article 15 propria moto investigations. But for all of these matters, the basic function of preliminary examinations must mean that they do not take any longer than they are required. I will announce in relation to new preliminary examinations, new investigations, certain situations where I will not open new cases and I will not conduct new investigations. I think this is in line with both the IER report, and it's also in line with the officer's policy on case completion. I will continue to solidify ongoing investigations. I gave my report recently on Libya to the Security Council, and I emphasize there that all things being equal, I will prioritize referrals by the Security Council. I demonstrated my adherence to this by, in August, going to Sudan. We agreed an MOU with the government of Sudan, and they also agreed to have our office open an office in Khartoum. Whilst the coup has caused a bit of a hiatus, I look forward to members of my office, subject to security and the issuance of visas, going to Khartoum again. We can look at the Sahel region, we can see the spread of ISIS. This is another area of concern to the office that we're reviewing. And in relation to Afghanistan, I made a decision based upon the evidence that the worst crimes in terms of gravity and scale and extent seem to be committed by the so-called Islamic State Khorasan and also the Taliban. And I said I would prioritize these, and I've asked the judges for authorization to open those investigations. I want members to recall that in 2014, my predecessor Fatou Bensouda, in relation to Darfur, told the Security Council that she would hibernate Darfur because of overstretched resources, and she was shifting those resources to other cases. I have not sought to hibernate, but I have sought in a very transparent way to explain where I will seek to investigate, what I will seek to prioritize, and what I would seek to deprioritize. We have to, every national prosecutor has resource issues. We have to use it wisely. But I'm a great believer in the wisdom of Voltaire, and as Voltaire said, perfect very frequently is the enemy of the good. And this is also something a prosecutor must bear in mind. The President has discussed the progress in courts in terms of the cases. The court is busier than ever. In Yakatom, in Ganasona, the Said case, we've dealt with 52 witnesses in Said. In the Al-Hassan trial, we are progressing, and the Deputy Prosecutor has been overseeing the imminent commencement of an Article 70 case. Regional engagement needs to move more closely, and I look forward to regional cooperation with Asia, with Latin America, and also with the African Union. And I've met President Tshisekedi, President of the African Union, President Macky Sall, the incoming President, and I look forward to meeting President Faki of the AU Commission soon in anticipation of addressing the African Union Heads of State Summit in Addis in February. A lot more can be said, but I had a note. I was told I could have 15 minutes, but it seems I got that wrong. It was 10 minutes. So can I just end by thanking Madam President, you for your support, the President, President Hofmansky, the Registrar, James Stewart, and really all of you for the support and the warm welcome in this initial period. I would like to also thank the outgoing chair of the Trust Fund for Victims, Mama Doumbia. Wish her the very best, and the work you do in your board is something we should never lose sight of, and we should all support, because it is immensely impactful for the individuals. My final word has to be this. I will not shirk my responsibilities. I will take the tough decisions in terms of the quality control of the office and where we focus. But I do ask the respected members of this Assembly of State Parties, our parents, the guardians of the Rome Statute system, to not shirk your responsibilities. I made a budget request. The court put forward a budget request. The CBF has recommended only half of what we say we needed in what was a very well thought out budget proposal from the court. I do ask that the respected members of the Assembly of State Parties work with the budget facilitator and at the very least meet what the CBF have recommended. And I think actually we do need more to harness technology. If we work together, if we fulfill the promise of this Rome Statute, we can do work that will outlast us, that will outlive us, and could make a very meaningful difference to so many who are suffering so much as we sit here in this room in The Hague. Thank you so much.
I thank the Prosecutor Khan for this extremely informative statement, also for his invitation to all of us to do better. I'm sure we all want to join in this invitation. And I now propose that the Assembly take note of the report of the International Criminal Court contained in document ICC ASP20/9. I see no objection. It is so decided. The Assembly has thus concluded its consideration of Agenda Item 10. Now, with your permission, I will switch into French to turn to the rapport du Conseil de direction du Fonds au profit des victimes. Distingués collègues, nous passons maintenant au point 11 de l'ordre du jour, un rapport du Conseil de direction du Fonds au profit des victimes, les rapports sur les projets et les activités du Conseil de direction pour la période allant du 1er juillet 2020 au 30 juin 2021 figurent au document ICC ASP2014. J'ai l'honneur de donner la parole à la présidente du Conseil de direction du Fonds au profit des victimes, Madame Mama Kwate-Doumbia.
Merci Madame la Présidente, merci infiniment pour cette considération. Madame la Présidente, Excellences, Mesdames, Messieurs, au nom du Conseil de direction au Fonds profit des victimes, je salue chaleureusement tous les délégués ici présents ainsi que ceux absents à cette session en raison des contraintes imposées de l'épidémie de Covid-19. J'ai le grand honneur de m'adresser à vous aujourd'hui pour la seconde fois devant cette auguste Assemblée des États parties en tant que présidente du Conseil de direction pour vous informer des activités entreprises par le Fonds au profit des victimes ainsi que nos réalisations à ce jour, mais aussi les nombreux défis auxquels nous sommes confrontés. Il s'agit également, pour la dernière fois, que m'incombera cet honneur dans la mesure où le Conseil de direction actuel arrive au terme de son mandat. À ce titre, je souhaiterais exprimer une fois encore ma reconnaissance à mes collègues, membres du Conseil qui m'ont élu à ce poste et qui m'ont cessé de contribuer activement à nos travaux, avec persévérance dans l'accomplissement de notre mission commune au service du Fonds des victimes. Je souhaiterais ainsi exprimer ma plus profonde gratitude à mes collègues, Madame la baronne Aminka Elik, qui représentait les États d'Europe, M. Cheikh Bilal Mohamed, qui représente l'Asie, Madame Minou Tavares Mirabel, qui représente les États de l'Amérique latine, M. Gaucha, qui représentait les pays de l'Europe de l'Est. Enfin, je souhaite la bienvenue à M. Andrés Parmas, qui a été nommé au Conseil de direction en avril de cette année, reprenant ainsi le mandat de M. Gaucha, qui est désormais juge à la Cour pénale internationale. Je remercie également les États parties d'avoir procédé à la nomination des candidats pour le nouveau Conseil de direction qui, je suis convaincue, sera perpétuer les succès des importantes contributions engagées par les membres sortants. Durant ces dernières années, nous avons donné le meilleur de nous-mêmes en apportant des innovations considérables par des idées, de l'énergie, de l'expertise et au-delà, le don de soi, puisque nous travaillons pro bono pour rendre plus performant le Fonds au profit des victimes et rendre plus visibles les actions. Ce travail a contribué à donner de l'espoir aux victimes survivantes, leurs familles, leurs communautés et la confiance plus accrue des partenaires et donateurs. De 6 projets en 2019, nous avons atteint à ce jour 28 projets, après d'âpres travail et sacrifices pour le Conseil et le secrétariat, y compris notre personnel sur le terrain. Madame la Présidente, Excellences, Mesdames, Messieurs, le Fonds au profit des victimes a multiplié ses efforts afin de poursuivre son travail dans les meilleures conditions possibles pour assurer en temps utile des mesures de réparation au profit des victimes, malgré l'épidémie de Covid qui affecte encore le monde entier. Les victimes, malgré leur vulnérabilité pour les préjudices subis, sont plus affectées, mais demeurent soutenues par le Fonds. À cet égard, il est important de souligner qu'en plus de la mise en œuvre des ordonnances de réparation, le Fonds a également poursuivi ses efforts dans le cadre de ses nombreux programmes d'assistance bénéficiant à des milliers de victimes survivantes de crimes atroces relevant de la compétence de la Cour. En effet, le Fonds au profit des victimes poursuit depuis maintenant plusieurs années sa bataille courageuse pour la justice réparatrice au profit des millions de victimes. même lorsque les auteurs des crimes concernés sont poursuivis devant la Cour pénale internationale. Le préjudice des victimes de ces crimes inconsolables ne peut être oublié et se doit d'être réparé de manière durable, profonde, tant au niveau individu qu'au niveau des communautés. Madame la Présidente, Excellences, Mesdames, Messieurs, le Fonds au profit des victimes a su faire face à de nombreux défis au cours de l'année qui s'est écoulée. Ce fut une année riche en activités et le Fonds met en œuvre à l'heure actuelle des réparations dans 4 affaires. 3 ayant lieu dans l'est de RDC, dans la province de l'Ituri, et une affaire dans le nord du Mali, qui continue malheureusement dans ces régions où il continue malheureusement à être en proie à des conflits violents, avec la complexité de l'épidémie de Covid-19. En cette fin 2021, le Fonds voudrait faire l'état des réalisations suivantes. Premièrement, dans le cas de l'affaire Lubanga, j'ai le plaisir de vous informer que le Fonds a commencé à mettre en œuvre des réparations par le biais de son partenaire d'exécution. Le Fonds a lancé en mars de cette année un programme de réparation collective basé sur des services au profit d'enfants soldats et leurs familles. Il est important de souligner à cet égard qu'il s'agit là d'un programme d'une complexité et d'un volume sans précédent et d'une valeur maximale de plus de 9 millions de dollars US pour une durée de 5 ans. Le Fonds est également sur le point de mettre en place un programme de réparation symbolique. Deuxièmement, dans l'affaire Takanda, le Fonds a lancé en novembre de cette année un programme visant à répondre aux besoins les plus urgents des victimes. Ces progrès considérables ont eu lieu alors que même la mise en œuvre des mesures de réparation se poursuit et s'accélère en dépit de nombreuses difficultés opérationnelles, en particulier en Ituri. Au moment où je m'adresse à vous, le Fonds est sur le point de finaliser le plan de mise en œuvre des réparations ordonnées par la Cour dans l'affaire Katanga, qui est étroitement lié au programme de réparation mis en place concernant l'affaire Lubanga, un processus de planification qui s'achèvera prochainement le 17 décembre. Troisièmement, dans l'affaire Katanga, l'achèvement des activités au profit de 297 victimes bénéficiaires est très proche, dans la mesure où la mise en œuvre du soutien au logement et du soutien psychologique sera fournie aux victimes éminemment. Il faut noter que ce travail en outre a été possible grâce aux efforts combinés du personnel du Fonds au profit des victimes, tant à Bunia qu'à La Haye, et des représentants légaux des victimes, avec le soutien important du greffe de la Cour, aussi bien sur le terrain qu'à La Haye. Quatrièmement, au sujet de la mise en œuvre des réparations dans l'affaire Almadi, l'identification des bénéficiaires individuels est désormais terminée et le Fonds a fait d'importants progrès concernant le versement des indemnités individuelles qui fut une action prioritaire. Des indemnités aux bénéfices ont été données à 774 descendants des saints associés au mausolée détruit et à qui on a octroyé des sommes très importantes. Parmi ces donations, ces réparations individuelles, 381 femmes ont été indemnisées et 393 hommes aussi ont été indemnisés à ce jour. Le Fonds procédera prochainement à la mise en œuvre des réparations collectives par le biais de ses partenaires d'exécution au profit des communautés de Tombouctou en entier. Celle-ci vise à répondre au préjudice moral et économique causé par cette dernière du fait des crimes pour lesquels Almadi a été condamné. Aussi, dans le cadre de la mise en œuvre de cette ordonnance de la Cour, une étape importante a été médiatisée, célébrée par le Fonds avec l'organisation au Mali de la cérémonie de remise de réparation symbolique de l'euro au peuple malien et à l'UNESCO, pour laquelle j'ai été honoré de co-organiser avec le chef de l'État du Mali le 30 mars à Bamako. J'ai été également très honoré à l'occasion d'être accompagné par Madame le procureur Fatou Bensouda à la cérémonie de Bamako et lors de ma visite dans la cité des 333 saints à Tombouctou, visite qui nous a profondément touchés et qui nous a permis de rencontrer des victimes de crimes pour lesquels Almadi a été condamné et de communautés vraiment affectées. Enfin, dans le cas de Dominique Ouangen, la procédure de mise en œuvre des réparations est encore à ce stade précoce. Le Fonds va soumettre ces observations aujourd'hui, le 6 décembre, en ce qui concerne le contexte opérationnel du futur programme de mise en œuvre des réparations sur la base des enseignements tirés de son programme d'assistance. Madame la Présidente, Mesdames, Messieurs, l'expérience du Fonds au profit des victimes dans la mise en œuvre des réparations a montré qu'il s'agit d'une activité nécessitant énormément de travail, des adaptations constantes aux circonstances opérationnelles qui ne cessent d'évoluer, un engagement continu avec les victimes et leurs représentants légaux, une collaboration étroite avec le greffe, tant au niveau de ses bureaux extérieurs que du personnel basé à La Haye, un alliage d'expertise juridique opérationnelle au sein du Conseil et du secrétariat. À ce sujet, je souhaiterais exprimer ma grande gratitude au secrétariat, en particulier au personnel sur le terrain, pour leur engagement constant et leur persévérance. Madame la Présidente, Excellences, Mesdames, Messieurs, je vous ravie de vous confirmer que le Fonds continue de déployer des programmes d'assistance, y compris dans les pays où le bureau du procureur de la Cour pénale internationale n'a pas entamé des enquêtes récemment. Le Conseil de direction a été soucieux de guider la mise en œuvre de 10 projets dans les provinces de l'Ituri et du Kivu du Sud et du Kivu Nord, en République démocratique du Congo. En outre, en République centrafricaine, le projet pilote de Bangui a été un grand succès et a permis de venir en aide à 200 bénéficiaires parmi les victimes les plus vulnérables des crimes sexuels et sexospécifiques continuent de bénéficier de notre assistance. Le Fonds entretient également des programmes d'assistance actifs en Ouganda et en Côte d'Ivoire. Enfin, j'ai le plaisir de vous informer que de nouveaux programmes sont envisagés en Géorgie, au Kenya et au Mali, et dans le cadre desquels des partenaires de mise en œuvre ont été sélectionnés, et les programmes commenceront le premier trimestre de l'année 2022. Madame la Présidente, Excellences, Mesdames, Messieurs, la mise en œuvre des programmes d'assistance constitue une partie essentielle du mandat du Fonds au profit des victimes. Il permet la reconnaissance des préjudices subis par les victimes de manière plus large que le mandat de réparation, complétant l'empreinte judiciaire de la Cour également dans les circonstances où les poursuites infructueuses risqueraient de laisser des victimes à l'abandon, comme en République centrafricaine, en Côte d'Ivoire, au Kenya, où il y a eu des relaxes purs et simples des présumés. En outre, le Fonds cherche activement à coopérer avec les programmes de réparation nationaux dans tous les pays et travaille avec la société civile, les associations de victimes pour la mise en œuvre des projets. Madame la Présidente, Mesdames, Messieurs, tout au long de son mandat de 3 ans, ce Conseil sortant a consacré un temps et une énergie sans précédent à la réforme et au renforcement de la bonne administration et la performance du Fonds. Mon rapport sur les activités de l'année écoulée témoigne de la transition significative du Fonds au cours des dernières années. Le Conseil de direction a plus étroitement, plus que jamais auparavant, offert des directives au secrétariat et à travers des réunions mensuelles, souvent bimensuelles virtuelles. Il a cherché à renforcer ses relations avec la Cour et avant tout avec le greffier, que je voudrais rendre hommage ici, qui nous a soutenus, qui a été notre conseiller constamment et qui a participé à beaucoup de nos réunions pour nous accompagner dans des prises de décision. Nous avons également apprécié l'évolution de nos relations du Fonds avec Madame la Présidente de l'Assemblée des États parties, Monsieur le Président de la CPI, Monsieur le Procureur, avec tous lesquels nous avons eu de très bonnes relations durant notre mandat. Au sein du Conseil de direction, nous avons abordé notre administration à l'échelle interne en adoptant pour la première fois une politique formelle sur les méthodes de travail de direction qui concernent également les relations avec le secrétariat. Mesdames, Messieurs, Excellences, concernant les perspectives futures, le Conseil a été plus que conscient des préoccupations concernant la bonne administration et la performance du Fonds au profit des victimes, telles qu'ont été exprimées dans le rapport du groupe des experts indépendants l'année dernière. Nous avons pris acte des points de vue et des idées des experts et nous avons travaillé avec ardeur avec les États parties, le greffier, le secrétariat pour traiter ces questions puisque d'importants défis nous attendent encore. L'intégrité de notre expertise et de nos capacités financières, juridiques et opérationnelles méritent d'être préservés à cette fin pour remplir notre mandat de justice réparatrice tel qu'il est envisagé dans le statut de Rome et dans notre règlement. Le Fonds ne peut pas y parvenir seul. Nous dépendons du soutien et de la coopération des États partis à qui nous rendons hommage pour tous les soutiens importants qu'ils ont apportés au profit des victimes, en reconnaissance de l'impératif de notre mandat de réparation, de la complexité de notre fonctionnement et de nos besoins de financement. Il va de même pour nos amis et collègues de la Cour. Il ne devrait pas y avoir de frontières entre nos esprits et entre nos actions. Et seul un véritable esprit de collaboration entre nos institutions permettra aux victimes de faire valoir leurs droits et de satisfaire leurs besoins pour surmonter leurs préjudices et retrouver leur dignité. Permettez-moi, avant de terminer, d'exprimer mon émotion, mais aussi ma gratitude en quittant cet espace où j'ai eu tout le soutien et l'admiration de beaucoup d'entre vous. Merci à vous tous et toutes pour m'avoir exprimé votre sympathie et souhait de bonheur dans le futur. Je voudrais, à ce moment de départ, remercier mon pays, le Mali, qui m'a soutenu, et à l'Union africaine pour avoir m'élu pour représenter les États d'Afrique depuis 6 ans. Je voudrais aussi rendre hommage et remercier mon secrétariat, les amis, tout le personnel de la Cour pour ce soutien et cet accompagnement. Je reste disponible pour soutenir les victimes dans une justice internationale au service de la paix. Je vous remercie.
Je remercie Madame Kouaté Doumbia pour sa déclaration et au nom de l'Assemblée, je le prie de bien vouloir transmettre à ses distingués collègues du Conseil de direction la reconnaissance de l'Assemblée pour leurs efforts inlassables et leur engagement en faveur des victimes. Je saisis l'occasion pour rendre un hommage spécial à vous, Madame Kouaté Doumbia, et à la baronne Arminka Helic, qui toutes deux quittaient le Conseil de direction. L'Assemblée vous remercie pour l'autorité dont vous avez fait preuve, votre travail acharné et votre dévouement personnel dans l'accomplissement du mandat du Fonds au profit des victimes, une composante fondamentale du système du statut de Rome. Je suis persuadée que vous continuerez à déployer votre énergie et votre engagement dans le but de protéger les personnes directement affectées par la violence et le crime. Au nom de l'Assemblée, je vous souhaite beaucoup de succès dans vos activités à venir. Je propose que l'Assemblée prenne note du rapport du Conseil de direction du Fonds au profit des victimes contenu dans le document ICC ASP20 14. Je ne vois pas d'objection. Il est ainsi décidé. Et nous avons ainsi conclu l'examen du point 11 de l'ordre du jour. We will suspend the meeting for a few minutes to allow the distinguished head of organs and the chair of the board to leave the podium at this stage. We thank you very much for your presentations today. Distinguished Distinguished representatives, I kindly ask you to return to your seats, so we will continue. We continue to address our agenda. Nous passons maintenant au point 6 de l'ordre du jour. Conformément à la règle 25 du règlement intérieur, une commission de vérification des pouvoirs composée des représentants de 9 États parties est nommée par l'Assemblée au début de chaque session sur proposition du président. Suite à des consultations avec les États parties et sur recommandation du Bureau, je propose de nommer Chypre, la Grèce, la Hongrie, le Mexique, la Roumanie, le Salvador, la Suisse et le Sénégal en tant que membres de la commission de vérification des pouvoirs. Puis-je considérer que l'Assemblée accepte ma proposition? Il est ainsi décidé. L'Assemblée nommera le membre restant de la Commission à un stade ultérieur. Je rappelle aux délégués que conformément à la règle 24 du règlement intérieur, les pouvoirs doivent émaner du chef de l'État ou du gouvernement ou du ministre des Affaires étrangères ou d'une personne habilitée par l'un ou l'autre d'entre eux. Et nous passons maintenant au point 7 de l'ordre du jour, organisation des travaux. Le programme proposé par le Bureau comme base de nos travaux durant cette session est reflété dans le journal de l'Assemblée en date du 3 décembre 2021. Je suis sûre que vous comprenez tous que le programme est sujet à modification selon l'avancement de l'examen des divers points à notre ordre du jour. Je demande à tous les représentants d'arriver à l'heure pour les réunions afin que l'Assemblée puisse conclure l'examen de toutes les questions à l'ordre du jour de la 20e session. Puis-je considérer que l'Assemblée adopte le programme du travail reflété dans le journal de l'Assemblée en date du 3 décembre 2021. Je ne vois pas d'objection. Il est ainsi décidé. Il est proposé par le Bureau que l'Assemblée se réunisse en plénière et tienne des consultations informelles sur les questions clés sur lesquelles il faudra prendre des décisions. Suite à sa réunion du 24 novembre 2021, le Bureau recommande que les personnes suivantes soient nommées coordinateurs de l'Assemblée pour cette session. Pour les groupes de travail sur les budgets, l'ambassadeur Francis Galatia Latnitou Williams de Chypre. Et pour les consultations informelles sur la résolution Omnibus, M. Vincent Rittener. Puis-je considérer que l'Assemblée souhaite procéder de la sorte? Je ne vois pas d'objection. Il est ainsi décidé. Je félicite l'ambassadeur Francis Galatia Latnitou Williams de Chypre et M. Vincent Rittener de Suisse et leur souhaite plein succès dans l'accomplissement de leurs tâches. Ils pourront tous les deux compter sur le soutien du Bureau. And now, distinguished representatives, we will now turn to agenda item 5, States in Arrears. While most state parties paid their contributions in a timely manner, the amount of outstanding contributions increased this year. This generated an extremely serious liquidity crisis in the last trimester that threatened the capacity of the court to fulfill its financial obligations. I note that taking stock of the crisis experienced in recent years, the Bureau started to consider the situation early on this year, continued to monitor the situation on an ongoing basis throughout the year, and later took appropriate actions to avert the crisis. I would like to thank the two vice presidents, the facilitators on arrears, and the registrar, and the facilitator on the budget for their tireless efforts to obtain payment of outstanding contributions. I also engaged personally with representatives of relevant states to this effect. I am happy to report that this collective endeavor resulted in some key payments being made, which combined with advance payments for 2022 by other states, averted the liquidity crisis from materializing. I thank the governments of state parties that made payments, either to remove or reduce arrears. I also wish to express my deep appreciation to those states that contributed to solve the situation by making advance payments for 2022, while underscoring that such advance payments should not by any means become a common practice of this Assembly. The lack of timely payment of contributions has become a recurring problem and thus a matter of serious concern. We need to keep this issue under review and continue to consider the relevant recommendations of the report of the Independent Expert Review, the Committee on Budget and Finance, and the external auditors and other bodies. As regards voting rights, according to Article 112, paragraph 8 of the Rome Statute, a state party which is in the arrears in the payment of its financial contributions towards the cost of the court shall have no vote in the Assembly and in the Bureau if the amount of its arrears equals or exceeds the amount of the contributions due from the preceding 2 full years. The Assembly may nevertheless permit such a state party to vote in the Assembly and in the Bureau if it is satisfied that the failure to pay is due to conditions beyond the control of the state party. The Secretariat sent a note verbal dated 15 November 2021 to all concerned states via their United Nations missions, as well as their embassies in The Hague and Brussels, informing them that they were in arrears, recalling the provisions of Resolution ICC ASP/4 Resolution 4 on the request for exemptions, as well as stating the minimum payment required to avoid the application of Article 112, paragraph 8 of the Rome Statute. In accordance with information provided by the Court, it would appear that Article 112, paragraph 8 of the Rome Statute is currently applicable to 9 states parties: Antigua and Barbuda, Central African Republic, Comoros, Congo, Guinea, Liberia, Suriname, Bolivarian Republic of Venezuela, and Zambia. The Bureau considered the question of requests for an the questions of potential requests for an exception from the loss of voting rights, taking into account a number of elements. The practice so far to grant all requests for waiver formally submitted by state parties, to which Article 112, paragraph 8 applies, the relevant recommendations of the Committee on Budget and Finance, including as its most recent September session, the particularly serious liquidity crisis, which posed a serious risk of affecting some of the court's operations, as well as the exceptional and unprecedented circumstances generated by the COVID-19 pandemic. In light of the above, the Bureau decided to recommend to the Assembly to grant the waivers if requested due to the exceptional COVID-19 circumstances faced by state parties in 2021. However, it was also agreed that the current practice in relation to such waivers could change in 2022 should such circumstances improve. I would like to underline the importance of endowing the court with the necessary financial resources. I encourage all state parties to transfer their assessed contributions in full and on time, or in the event of pre-existing arrears, immediately, in accordance with Article 115 of the statute and Rules 105.1 of the Financial Regulations and Rules. I would also like to invite other state parties that are subject to Article 112.8 of the Rome Statute that wish to request an exemption from the loss of voting rights to submit a formal request via the Secretariat of the Assembly of State Parties. Now we turn to item 11 of the agenda, which is review of the International Criminal Court and the Rome Statute system. The Assembly has before it the report of the review mechanism submitted pursuant to ICC ASP/19/Resolution 7, which is contained in document ICC ASP20/36. I will now give the floor to the two state parties' representatives who have led the work of the review mechanism in The Hague and in New York, Ambassador Paul van den Ijssel from the Netherlands and Ambassador Michael Kanu of Sierra Leone. I invite them to come to introduce their reports from the lectern.
Gracias, President. It will be a two-man show. Michael will join me, and he will do the second part of the report. And we try to be relatively short because we will have a substantive meeting on the review this Wednesday. So I thank you very much, Madam President, for giving us the possibility to introduce the report of the review mechanism, which we submitted pursuant to ICC ASP19 Resolution 7 of last year, paragraph 9. In that resolution, the Assembly has requested the mechanism to submit a report on the review process well in advance of the 20th session. And I do apologize a little bit because the well in advance became only a couple of days. I hope for some understanding. In the report, we should say something on the progress in the assessment of and possible further action on the recommendations of the independent experts review and the measures for implementation of the review process. We should say something about progress in the work of the relevant Assembly mandates on the issues referenced in ICC ASP18 Res 7, paragraphs 18 and 19, and any other progress in the review process. The report indicates that the review mechanism carried out the tasks requested of it and lists the reports which the mechanism submitted, namely the categorization of the independent expert recommendations and remaining review issues, which is submitted to the Bureau on 30th of April and which the Bureau adopted on the 31st of May 2021. On the 30th of June, the review mechanism submitted a proposal for a comprehensive action plan for the assessment of the recommendations of the independent experts, which the Bureau adopted on the 28th of July 2021. And by adopting the Comprehensive Action Plan as proposed by the review mechanism, the Bureau accepted the working method proposed by the review mechanism, in which states parties will be involved in the discussions on the assessment and implementation of recommendations, giving effect to the need for continuing inclusivity and transparency, in accordance with Resolution 19-7 of last year, by designating platforms for discussion of all recommendations. Also on the 30th of June, the mechanism submitted a report on the overall progress of work. The Comprehensive Action Plan sets out the timeline for assessment of the IR recommendations. The second half of 2021, dates in 2022, and a few remaining ones in 2023. It also indicates the entities that are responsible for the assessment. The work of the mechanism on this comprehensive document was complex and benefited greatly from the inputs of states parties, ASP mandate holders, the ASP presidency, the court focal points, and individual officers of the court, the Staff Union Council, civil society, and ICCBA. As part of its working method, the mechanism routinely consulted these entities at each stage of its work. We note in the report that, like the categorization, the review mechanism considers the Comprehensive Action Plan as the roadmap for the assessment of all the recommendations throughout the review process. The mechanism noted that some recommendations were assessed earlier than the timelines in the Comprehensive Action Plan, and we welcome, of course, this progress. At the same time, we also note that the assessment of some recommendations expected to be completed in 2021 is still ongoing and will be completed in 2022. We welcome the work of the facilitators on the IR recommendations and are grateful that they considered the recommendations that had been assigned to them in the Comprehensive Action Plan as the platform of discussion. The mechanism also submitted a further report on its role as the platform for the discussions of recommendations which is assigned to itself. That means those recommendations for which the review mechanism itself serves as an ASP mandate holder in accordance with the resolution. Finally, the review mechanism submitted the report of the review mechanism. The report I'm now introducing. This report also contains two annexes. Annex 1 is the list of reports of the Assembly mandate holders that report on their work on the respective IER recommendations. Annex 2 contains a matrix titled Progress in the Assessment of the IER recommendations. I stop here and ask my dear colleague and friend Michael Carney to take over. Michael, please.
Thank you, Ambassador van der Ijssel. Madam President, Excellencies. As indicated in our message by which we circulated the metrics on Friday, the metrics is a purely factual overview of the state of the review as an informative tool to state parties and other stakeholders. It should be read in conjunction with the Comprehensive Action Plan. It covers those recommendations that were due to be assessed in 2021 according to the Comprehensive Action Plan. Where some recommendations indicated in the Comprehensive Action Plan for assessment in 2022 were already assessed this year, the outcome of those assessments has also been reflected. We noted in our report that the matrix contains information from the report of the different facilitations, and once more we thank and commend the ASP mandate holders for their work in having all the recommendations assigned to them assessed. We also indicated that the information on implementation deadlines is also taken from the reports and was also cross-checked with the court. Also, I would like to once more stress that these timelines were meant to be indicative and can be further discussed in the appropriate facilitations. We would like to highlight that in the metrics, that the matrix is a living document and we intend to update it regularly in order to provide a regular overview of the state of review. This also means we address mistakes in the matrix on an ongoing basis as we consult with the Assembly mandate holders and the court focal point. The review takes full responsibility for all or any of the mistakes you will find in the matrix. As we are aware, the review mechanism is currently holding negotiations on a draft standalone resolution on the review of the court and the Rome Statute system. We have made significant progress, and there are a couple of outstanding issues which we hope to resolve during the course of today's through an informal discussion, as well as the informal consultation that will take place this evening at 1800 hours after the general debate. And we hope to finalize the text today, and we look forward to your cooperation and constructive engagement. Finally, Madam President, I wish, on behalf of all the members of the review mechanism, to express our deep appreciation to the court focal point, Mr. James Stewart, Deputy Prosecutor, Mr. Hirab Abtai, the Chef de Cabinet of the ICC Presidency, Mr. Osvaldo Zavala Giller, Senior Special Assistant to the Registrar, for their consistent dialogue, their openness and willingness to share ideas and information. They have greatly assisted the review mechanism in its mandate during this year. The state party representatives are grateful to the Ad Country Focal Point, Bangladesh, Chile, and Poland, for their unstinting support and positive spirit, which has greatly facilitated our work. We also express appreciation to other staff of the court, the Staff Union Council, members of civil society, and the International Criminal Court Bar Association, those who have made valuable contribution to our deliberation. We also wish to thank the staff of the Secretariat of the ASP for their dedicated work in assisting the review mechanism in this important work in challenging circumstances and within the ambitious timeline. This concludes our report, Madam President, and I thank you for your kind attention.
Thank you very much. I thank Ambassador van den Eysel and Ambassador Kanu for the introduction of the report. I would also like to thank them both, as well as the other members of the review mechanism, for their tireless efforts in fulfilling their crucial mandate. As already indicated by Ambassador van den Eysel, we shall revert to this agenda item at our plenary meeting on Wednesday afternoon. Now, distinguished delegates, let us now turn to agenda item 4 on election of Bureau members. You will recall that at the first resumption of the 19th session, the Assembly elected the members of the Bureau for the 20th to 22nd sessions and noted that at the Bureau's 17th meeting on 12 January 2021, the Bureau had taken note of the seat-sharing arrangements agreed by the group of Asia-Pacific states and the Western European and other states groups. In order to ensure a seamless transition of Bureau members where there has been an internal seat-sharing arrangement, and to dispense with having an election of some Bureau members at each session of the Assembly, the Bureau recommends that the following members of the Bureau be elected according to the internal agreement as follows. In the Asia-Pacific group, Bangladesh would be elected for 2023. Japan and the Republic of Korea would be elected for 2022-2023. And in the Western European and other state groups, Germany would be elected for 2022-2023 as of 13 February 2022. Does the Assembly agree to proceed in this manner? I see no objection. It is so decided. Thus, Bangladesh is elected Bureau member for 2023, Japan and the Republic of Korea for 2022-2023, and Germany for 2022-2023 as of 13 February 2022. We have thus concluded our consideration of item 4. Now, before we move on to the next agenda item, I wish to indicate that the Bureau decided to recommend that the Assembly appoint Mr. Jules Thierry Legbo, Côte d'Ivoire, as rapporteur for the 20th session. Does the Assembly agree to appoint Mr. Jules Thierry Legbo, Côte d'Ivoire, as rapporteur for the 20th session? I see no objection. It is so decided. Let us now turn, distinguished colleagues, to agenda item 14, election of the members of the Board of Directors of the Trust Fund for Victims. The Assembly will now proceed to elect 5 members of the Board of Directors to fill the vacancies arising upon the expiration of the terms of office of the members of the Board elected at the 17th session. The note by the Secretariat contained in document ICC ASP20/18 sets out the procedure for the election of the members of the Board pursuant to Resolution ICC ASP/1 Resolution 7. At its 4th meeting on 2 June 2021, the Bureau fixed the nomination period to run for 12 weeks, from 7 June to 29 August 2021 Central European Time. At the end of that period, since the number of candidates remained less than the number of seats, and in accordance with Resolution 7, paragraph 4, the nomination period was extended to 12 September. At the close of the nomination period, 5 candidates had been nominated for the 5 available seats. The list of candidates and the supporting documents are contained in the note by the Secretariat entitled 7th Election of Members of the Boards of Directors of the Trust Fund for Victims, ICC ASP/20/18. This list of candidates goes as follows: Mr. Sheikh Mohammed Belal, Bangladesh; Mr. Kevin Kelly, Ireland; Mr. Andres Parmas, Estonia; Ms. Minerva Josefina Tavares Mirabal, Dominican Republic; Mr. Ibrahim Sori Yilal, Sierra Leone. The curricula vitae of the above-mentioned candidates and supporting documentation are contained in the annex to the note by the Secretariat. Paragraph 3 of the annex to Resolution ICC ASP/1/Resolution 6 on the establishment of the Trust Fund provides, and I quote, "The Assembly shall elect the members of the board, all of whom shall be of a different nationality on the basis of equitable geographical distribution and taking into account the need to ensure equitable gender distribution and equitable representation of the principal legal systems of the world. The members of the board shall be of high moral character, impartiality, and integrity, and shall have competence in the assistance of victims of serious crimes." Resolution ICC ASP/1/Resolution 7 on the procedure for the nomination and election of the members of the board provides in paragraph 8 for the regional distribution of seats as follows: African states, 1 seat; Asian states, 1 seat; Eastern European states, 1 seat; Group of Latin American and Caribbean states, 1 seat; and Western European and other states, 1 seat. Paragraph 9 of Resolution ICC ASP/1/Resolution 7 provides that the election of members of the Board of Directors shall be a matter of substance and subject to the provisions of Article 112, paragraph 7A of the Rome Statute. Paragraph 10 of the same resolution provides that every effort shall be made to elect the members of the board by consensus. The requirement for a secret ballot shall be dispensed with if the number of candidates corresponds to the numbers of seats to be filled, or in respect of candidates endorsed by the respective regional group, unless a delegation specifically requests a vote. Distinguished delegates, since the number of candidates corresponds to the number of seats to be filled, I would propose, on the basis of the 3rd November 2021 recommendation of the Bureau, that the Assembly dispense with a secret ballot in accordance with paragraph 10 of Resolution ICC ASP1 Resolution 7 and elect the candidates by acclamation. Is this agreeable to the Assembly? I see no objection. It is so decided. The Assembly therefore elects by acclamation the following 5 members of the Board of Directors of the Trust Fund for Victims: Mr. Sheikh Mohammed Belal, Bangladesh; Mr. Kevin Kelly, Ireland; Mr. Andrés Parmas, Estonia; Ms. Minerva Josefina Tavares Mirabal, Dominican Republic; Mr. Ibrahim Sori Gilach, Sierra Leone. The 3-year terms of office of the members of the board elected at this meeting will commence on tomorrow, 7 December 2021. On behalf of the Assembly, I congratulate the members of the Board of Directors of the Trust Fund for Victims and wish them every success in their discharge of their important responsibilities towards the victims of the crimes within the jurisdiction of the court and their families. The Assembly has thus concluded its consideration on Agenda Item 14. We shall now take up Agenda Item 15, election of the members of the Advisory Committee on Nomination of Judges. I wish to recall that Article 36, paragraph 4C of the Rome Statute provides as follows. The Assembly of State Parties may decide to establish, if appropriate, an advisory committee on nominations. In that event, the committee's composition and mandate shall be established by the Assembly of State Parties. The terms of reference of the Advisory Committee on Nominations set out in document ICC ASP/10/13, which is the report of the Bureau on the establishment of an Advisory Committee on Nominations of Judges of the ICC, provide inter alia that the committee should be composed of 9 members, nationals of state parties, designated by the Assembly of State Parties by consensus on recommendation made by the Bureau of the Assembly, also made by consensus, reflecting the principal legal systems of the world and an equitable geographical representation, as well as a fair representation of both genders based on the number of state parties to the Rome Statute. At its 3rd meeting on 12 May 2021, the Bureau fixed the nomination period to run for 12 weeks from 7 June to 29 August 2021 Central European Time. Nominating states were requested to include a statement as to how candidates fulfill the criteria established in the terms of reference of the Advisory Committee. At the end of that period, since the number of candidates remained less than the number of seats, the nomination period was extended to 12 September. At the close of the nomination period, 9 candidates had been nominated for the 9 available seats. The list of candidates and the supporting documents are contained in the note by the Secretariat entitled Election of Members of the Advisory Committee on Nomination of Judges, ICC ASP20/19. On 24th November 2021, the Bureau agreed to recommend that the Assembly elect by acclamation the following 9 candidates to the Advisory Committee on the Nomination of Judges. Mr. Denis Dominique Adjei, Ghana, Mr. Julian Fernandez, France, Ms. Lucy Mutoni Kambuni, Kenya, Ms. Milika Kolakovic-Bojovic, Serbia, Mr. Erkki Kurula, Finland, Ms. Sanji Masenono Monaghan, Botswana, Mr. Mauro Politi, Italy, Mr. Eduardo Rodriguez Belce, Bolivia, and Mr. Sang-Hyu Song, Republic of Korea. The terms of reference of the Advisory Committee, as I just explained, require that the members be designated by the Assembly by consensus. I understand that some additional time is required for consultations, so we will thus need to defer the election and revert to this item at one of our next plenary sessions. Distinguished delegates, we have concluded our business for the first plenary meeting. We will meet here at 3 p.m., 15 hours sharp, to begin the general debate. I wish to announce that the Credentials Committee will meet immediately following the adjournment of this meeting in the Antarctica Conference Room. Members of the Credential Committee may use the door to the left, to go to the conference room. I wish you all a pleasant lunch break and see you back here at 3 o'clock.